Trex. Again, let me thank you for allowing me the opportunity to share some reflections on a suit that I encountered years ago and give my personal perspective on it and perhaps help you understand just a little bit about the process that some of you may find yourself in if you're unfortunate enough to be caught up in a professional medical liability litigation. What I hope to do is to provide some insight into the medical legal process by sharing some personal information and to help you understand and recognize the stress and emotional impact that accompanies malpractice litigation. I'd like to review some resources that are available for you in case you do become involved. And I'm going to share some information on the effect of litigation on physician performance and hopefully encourage you all to gain a healthy respect for and confidence in the medical defense team that stands behind you. Of course, the legal elements of medical malpractice include your duty to accept responsibility for caring of your patient. A deviation from the standard of care is necessary in order to bring forth a legal action against you. There has to be a direct causal relationship between your act and the injury that came to the patient, and there have to be damages. When all of those are present, of course, then you're susceptible to suit. My situation was one in October of 1988, within about 3 weeks of joining the staff at the Mass Eye and Ear Infirmary, when I was sitting in my office and received an envelope, and on it was stated, when I opened it up, you have been sued. Notify your malpractice insurance carrier. Naturally, this came as a real shock to me because I had no idea where this was coming from, and I didn't really understand the circumstances. If you think what your reaction to something like this might be, it could be like mine, which was a combination of all of these. I think disbelief, an element of fear, an interjection of almost immediate self-doubt, certainly anxiety, bewilderment and wanting to understand what had happened, some element of feeling guilty to be named in a lawsuit, depression, anger, a feeling of isolation or what might be coming, certainly a strong element of self-reflection. I think these are all natural for anybody that goes through this process to feel, and I certainly felt all of them going through the process. I'll ask this question, and please respond by marking or pressing the button. When sued, the physician's common initial reaction is A, anger, B, frustration, C, depressed mood, D, feelings of guilt. Not surprising, there's good data, and it is a combination of all of these, but the most common one is that of anger. In a survey of 154 physicians who had been sued that was done a number of years ago, 123 physicians felt anger as their initial response. This is followed shortly thereafter by depressed mood and frustration and the other things that I alluded to in my previous slide. And the severity was significant. In my particular situation, I think there was a large element of anger. Other people have come along since that time and have divided these symptom clusters into one of depression and one of anger. And some of the types of things that would show up as in a category of depression might be a dysphoric affect, insomnia, a feeling of feeling defeated, difficulty in concentration, low self-esteem, and certainly I felt an element of some of these, although I am a person who fairly easy, as my wife will remind me, to compartmentalize things, and so I could continue on it didn't affect my job so much, but it certainly occupied a lot of my time when I wasn't concentrating on my patient care, and I'll come back to that issue in a moment. I think anger is one that you might think is directed towards the process or the legal situation that you find yourself in, or to the patient who brought the plaintiff who brought the suit against you. In my situation, I think the anger was more directed at myself, to thinking, how did I get myself into this situation, and what am I going to do about it? And there was certainly an element of hostility towards those other people, but there was always this element of, John, why did this happen to you? And so some of the anger was directed internally. Now, this is a problem for physicians because it can lead to serious illnesses. In fact, in that group that I was speaking about earlier, 11 physicians reported onset of new physical illnesses. It's kind of a psychosomatic response to what's going on in your everyday life that's leading to problems in your physical health. 3, for instance, had an acute coronary events during the litigation process. And 10 physicians reported exacerbations of existing illnesses such as angina, ulcers, irritable bowel syndrome, hypertension. Well, what's the background for my particular case? It was not an ophthalmology case. The setting was back in 1985 when I was working in the emergency room at Hendricks Medical Center in Abilene, Texas. In those days, many physicians in the military and some of the people that were residents and in training at that time moonlighted, so to speak, in emergency rooms because there was no specialty of emergency room medicine and there was an opportunity to earn a little additional income. And I had certainly had completed an internship in general surgery and felt very comfortable in being able to manage trauma and medical problems in an emergency room setting. The time was around 11 p.m., and I was the only emergency room physician on call when a 10-year-old male came in. He had been traveling with his family from Dallas to El Paso, where his father and mother lived and where his father needed to be work on Monday. It was a Saturday night. He was accompanied by his father to the emergency room, and his mother stayed with the other children in the waiting room. His dad had to be to work on Monday, and I was well aware of that. The history was one in which the child had fallen and had pain near his left hip. My examination was essentially what you might expect. There was some lower extremity pain and tenderness, but full range of motion. The distal neurovascular system was intact. There was mild tenderness near the greater trochanter. The radiology, fortunate for me, the radiologist had read the film and reported no hip or a normal hip, femur, and all the images were essentially negative. And I also had a wet reading when I looked at the films, and that was my assessment as well. And this was confirmed in a written report by the radiologist later. In those days, CT scanning was not performed. The diagnosis, my working diagnosis, was one of a contusion of the soft tissues of the bone. I was well aware that sometimes fractures don't show up acutely and that this could be a possibility. My decision then was whether to admit the child for observation or to let the family continue on to El Paso and have the child seen on Monday. There was a strong motivation on the part of the family, and particularly the father, to get home because he needed to be at work. And I made a decision to discharge the child to the care of his father. And I instructed Dad very specifically, and I could, believe me, recall the conversation very clearly in my head, that I had instructed the dad to take the child to see the family doctor on Monday upon arrival in El Paso, and that I would allow weight bearing as tolerated. Well, what happened? Dad did not take the child in on Monday. In recollection at deposition, his statement was, as the ER doctor told me, there was no fracture. 3 months later, the child began to limp. 9 months later, the child could not bear weight. Eventually, a fracture was discovered with non-union and early joint degeneration, and the child had to have this surgically repaired. The claim, of course, when you get these claims in the mail, they make you sound like the very worst thing on the face of the earth. I mean, it is really hard to sit there and read this. They claimed that I'd failed to diagnose the hip fracture, that I'd failed to admit the child to the hospital, that I had failed to obtain appropriate consultation with an orthopedic surgeon that night, that I'd failed to instruct the family on follow-up care, and that I'd failed to inform the family of the consequences of the injury. Those were the allegations. Well, what were the damages? Late surgery was required. The child was going to have some arthritis in his hip at an early age. Perhaps he was going to need hip replacement at an earlier age in life, and that he might have a hindrance to his quality of life in terms of athletics and limited employment opportunities, and of course there had been some pain and suffering. The demand was for $1.5 million, and these included both medical expenses past and future loss of wages. There, of course, were pain and suffering is always an allegation. Now, here I was as a young, relatively young physician, 6 years out from my fellowship training, and I was asking myself, who do I turn to and what do I do and what are my next steps? Unfortunately, I didn't have an insurance company that's quite as good as the one that covers me now, and I learned an awful lot about professional liability litigation during my experience. So here's the next question. When confronted with a claim letter from a plaintiff's attorney, your first step should be to, 1, call or write the attorney and ask for more information, get out the chart and look for inculpatory evidence that may be harmful to your case. Inculpatory evidence would be information that's contained in the chart that you might consider to be damaging to your case. Contact your professional liability insurance carrier or review the demand letter with your partners. Well, I see that everyone's got the message. That's absolutely right. Contact your professional liability insurance. That is your best line of defense. There's no better place to turn, and in fact, it's essential that you do that in order to trigger coverage under your insurance policy. And it doesn't matter which carrier that you have your insurance with. It's essential that you get in touch with your insurance carrier and talk to the claims people. Now, the follow-up question is, when should you contact your professional liability carrier? Answer number 1, a letter or phone call from an attorney requesting money to settle the matter, a phone call from a patient requesting my money back, a letter from an attorney notifying you of a pending suit, or 4, all of the above. That's correct, all of the above. Remember that a request for money is considered a claim, and it needs to be reported. A claim can be defined as a written notice or demand for money or services. A potential claim, on the other hand, is an oral notice of an adverse outcome that you may have discovered or know about, some event that occurred that you're not comfortable with, and these are sometimes known as incidents. And it's very helpful for you to feel free to discuss these with the insurance company, but usually you're going to be referred to the risk management department to discuss these types of incidents, and you are going to be discussing it with a claims representative. The reason that insurance companies like to know about these incidents is because it gives them some idea of the potential claims that are going to arise. They actually have statistics that will say how many claims are going to rise out of so many incidents. So it's helpful for them, but it also certainly begins the process of sequestering information that may come in, or if they're contacted by a patient or by an attorney, they're already alerted to the fact, and their antennae are up and ready to respond on your behalf. So remember that even in incidents, it doesn't count against you, and it's important for you to contact your insurance carrier for any of these types of things. Also remember that the demand may come from a patient, a parent, a legal guardian, or an attorney representing the patient. So just because it doesn't come from an attorney is no reason not to get in touch with your carrier. Now, most insurance companies have these 4 departments. The claims department that's going to handle your claim, the risk management department, which some companies are stronger than others in this arena. They're going to have underwriting, which you've heard about today, and of course we have to handle the finances, the business of running the operation. There are many very good insurance companies in the United States, and here are some that are in the New England area. Many of you are probably insured by them and not by OMIC. And all of them will have some of the elements that I'm talking about. If you haven't had experience with them, I'm sure that they will be happy to hear from you if you're having problems. Now, it's important to understand that there is a division between the risk management and the claims folks. They do talk to each other, but they don't always share information. Unless it's necessary. So you can speak to your risk managers with great confidentiality, and they're not necessarily going to go running down the hall to get in touch with claims to talk to them about it. But they may ask in a generic fashion sometimes about incidents or problems that they think could develop into a claim, and they will try to work on your behalf to help you work through the issue. The claims team, on the other hand, is very, very important because these are the people that are going to handle your situation from the beginning to the end. They usually consist of a combination of claims specialists. These people have usually worked for 10 or 20 years in this process. They're not always just ophthalmology claims specialists. They may have come from other backgrounds, but at least in the situation with OMIC, they're all extremely experienced people. Also, they're board and committee members. At least at OMIC, the board and committee members review almost every single claim that comes in before it goes very far. And there's a very important reason for doing that because it gives the claims team some heads up on things to look for, whether this is likely a case that needs to be settled, what are their potential liabilities, and what do we need to be looking for. Then there are the attorneys, and the attorneys are extremely important in your particular case. It's important to find an attorney that knows the medicine. They don't know the medicine are not going to be able to help you very much. We'll talk about that more in a minute. And then, of course, the consultants and expert witnesses that you can help the claims team identify that are going to work on your behalf. These claims specialists, defense attorneys, experts, and board members go through a process that begins with interrogatories. Interrogatories are a series of questions that the plaintiff's attorney will send to you that you have to answer. And you need to answer those with the assistance of your attorney so that you don't put down information that is going to later harm you or exclude information that will allow the plaintiff's team to point fingers at you because you're trying to hide things from them. So it's important that you not take those interrogatories and just don't give them any thought and send them back in thinking that nothing is going to come from them. They're very important. Discovery follows and may go on for 2 or 3 years. Discovery is a process where both sides, plaintiffs and defense teams, have the opportunity to get information, review the case, talk it over with their experts, hunt for more information, and they dig very deeply, believe me. Then there's the designation and review by experts. And this is an important part because the designation of the plaintiff's expert and the designation of the defense experts are very key pieces. They're going to be the ones that educate the jury and the court about the standard of care and what happened. Their job is to explain and to give their opinion about the medicine that is the crux of the case. Then there's going to be, at some point, an assessment of the strength of the legal case, and then a discussion between the attorneys, the claims team, and the doctor regarding settlement. There's going to be a decision whether to take the case to trial, and then there's going to be trial preparation and hopefully not a trial, but sometimes that's what has to take place. Now, what happens as the insurance company reviews this kind of information and shares their and prepares their defense strategy? I think this is important for people to understand that a lot of thought goes into this. This is not just a matter of a claims specialist or an attorney saying you need to settle this case. That just isn't the way it happens. There's so much effort that's expended into this, trying to position the defense team into an appropriate management of the claim. So some of the questions that they will ask are, for instance, is the case defensible? I mean, there are some cases that, quite honestly, need to be settled. They're just not defensible. Something happened. A perfect example might be somebody put a bovie pad on and they, got a burn. Probably there's a malfunction and something just needs to be settled. Or it could be something that's so egregious that we know that this is no way that you can defend this case. Those cases are pretty easy to identify in some situations, and there's probably going to be a settlement. But other questions that might be asked is the likelihood of a defense verdict. What are our chances of winning? Or what are our chances of losing? And that really is sometimes hard to determine. You do your best, but you don't really know for sure. There has to be an assessment of witnesses. There are some physicians, quite honestly, who are not very good witnesses. There are some physicians who are outstanding witnesses, and that can make such a difference in a trial because juries want to believe physicians. They trust them, they care about them, and they want to believe you, but you have to be believable in your testimony. Likewise, there are some plaintiffs' witnesses that are extremely sympathetic to the jury, and there's other ones that, quite frankly, turn juries off. And so your legal team and your claims representatives are going to be making that assessment, and they're going to be judging not only that, but also where is this trial taking place. We know that there are certain venues across the United States where you really don't want to take cases to trial unless you absolutely have to. Most insurance companies, I know for sure OMIC, is not afraid to take a defensible case to trial. They will defend you to the hilt, but they do look at the venue, and they put that as one factor that they have to assess in terms of trying to say, do we have a chance here? What is the settlement value? Sometimes it's much more expensive to take a case to trial than it is to settle the case. Now, OMIC, for instance, won't settle a case without approval of the doctor, but nevertheless, if there can be a settlement and it's reasonable, sometimes it avoids all of the emotional trauma of having to go through the trial and the possibility of losing if there can be a settlement. So that has to come into the discussion. What is going to be the value of the settlement if there is going to be a settlement? What's it going to cost to defend it, and what it's going to cost as an indemnity payment to the plaintiff, either in settlement or at trial? And finally, and very importantly, what does the doctor want to do? Now, what about the doctor? Well, he has or should have a very close working relationship with his claims representative. He's the contact person for the insurance company that he can work with, and with the legal team. But outside of those two resources, he doesn't have a lot of places where he can go for help. Certainly if you're having emotional problems, you need to discuss it. You have the option of going to your priest or a professional that has attorney-client privileges, and you can discuss those things that affect you emotionally and those types of things. But you have to be very, very careful about discussing the medicine, certain aspects of the case, because you can get yourself into trouble in that regard. Your attorney and your claims representative can help you a little bit in guiding you towards what you can discuss and with whom. Don't hesitate to consider getting professional medical attention if you need it. This is people, and I was like this, I think, to a certain extent. You tend to internalize these things, and you want to keep it very private. You don't want people to know. You're standing up in front of your peers and colleagues. You're supposed to be a leader. You're supposed to be teaching people. Yet you've got this thing that's going on in the background, and it really can be stressful for you. Please don't forget your spouse, because your spouse or your significant other is feeling your pain, believe me. And some people take it out on their spouse, and relationships have deteriorated because of that. They can also be a huge pillar of support, and I would ask you to consider reaching out to them to kind of help you through it. In the recent past 25 years, there has been a huge literature and support for people undergoing this process. At the time that I was, it was just kind of at the time when people were beginning to see a lot of malpractice cases coming on board. And over the next 25 years, there's been a whole team approach to helping physicians cope with the stress of a medical malpractice. And this organization, physicianlitigationstress.org, is very helpful. They have a lot of really good literature for you to read, articles for you to read, resources for you to use in coping it. There's a nice article on relationships during litigation, and several articles on stress, as I've alluded to. OMIC likewise has a large number of documents on their website that are very helpful in getting you through this process, and it's a good place to start to kind of read up about it. It gives you something to do besides thinking about how your testimony is going to go. And some of these are along the lines of psychological and emotional impact of being sued. Here's the next question. With whom may you discuss details of a case? 1, partner or colleague. 2, authoritative expert to get his or her opinion. 3, subsequent treating physician whom you know and trust to look and who took over the management of your case. Or 4, none of the above. It's absolutely correct. You really are limited in your ability to consult with others, and you certainly are going to be in trouble if you start asking to people that can be called into court and giving testimony about conversations you've had with them. So be very, very careful and follow the advice of your attorney and your claims representatives in this region. None of the above. Well, here's my concerns. What should I do? As thinking about this in the year and a half that I was going through this, I was convinced in my own mind that I had done nothing wrong. I felt that the medicine was correct. I thought the father was the cause of the child's problem. In fact, I was absolutely convinced that he hadn't done what I'd told him to do and it was his fault. However, I was aware of some other things, and one was that the demand far exceeded my coverage, which was for $100,000. The demand was for $1.5 million. And believe me, that gave me a lot of sleepless nights. So, in thinking about the standard of care, I hadn't missed the diagnosis. I hadn't rendered improper treatment in my mind. I hadn't failed to admit the child. My failure to admit the child didn't fall below the standard of care. Certainly, there was some damages, and the injury had caused the problem, but I didn't think it was due to my negligence. There was a problem, and it had to do with documentation. ER forms in those days, it was a one-day form. Now, I'm a compulsive documenter, right? So I filled up all of the space on the form with all of this really good information about the range of motion and the tenderness and the x-rays and all of this stuff. And I'd even written down my recommendations, but what I didn't write, because I ran out of room and I was too lazy to walk 20 feet to get another sheet of paper and sit down and write it down, I had failed to document my conversation and instructions to the father. In those days, we didn't have instruction sheets that you give to people for every little sprained finger and wound care and this kind of stuff. It was up to the doctor to do it, and I looked the guy right in the eye, and I told him what I thought, and I thought he was going to do it. So, trouble. Documentation. This is the fine little lines that legal cases depend on, and that's the trouble in this situation. Well, then I started talking to the insurance company, and what do they want to do? And of course, they talked about settlement. We talked about trying the case. We talked about defending it if I insisted on it. My experts kind of told me that the documentation was an issue. I needed to think about that. My attorney alerted me to the fact it was that. And so it boiled down to, what do I want to do? And my concern was that if I didn't get out of this case, I might be in it for $400,000, $500,000, $600,000 out of my own pocket, all of which I didn't have as a retired military officer and a newly employed staff physician at the Mass Eye and Ear Infirmary. Sorry, Joan. Right. So what if your financial responsibility exceeds policy limits? Well, one of the things that you can do, and what I did, was to write a letter to my insurance company to instruct them to settle at policy limits if possible. And I did this as a protection upon the advice of my private attorney because it puts the insurance company on notice that I really wanted to try and get this case over with if I can. What were some of the concerns that I had about taking it to trial? Well, I had a personal feeling that there was an element here where I had failed to meet the standard of care, and I'll come back and talk about that in a minute. I knew that I had a problem with documentation. The case was a child. That's always a bad sign. There were significant damages. And I had personal risk at financial exposure, and I kind of felt like I wanted this case over with. Well, what about this standard of care? I had already mentioned that as I reviewed the case, I had done everything that I thought I should do and that I had met the standard of care. But as I got to thinking about it and reflecting on it, and believe me, I munched over this for a long period of time, I really felt that I had failed in my duty to communicate with the father, and that that's part of the standard of care. For instance, mom was available. If I'd gone out to the emergency room and brought her in, she was probably much more likely to take that child to the to their family doctor on Monday than was the father. And so, in a sense, I kind of felt like I had not lived up to my duty as a physician in terms of communication with the family, and that might come up, and it bothered me for a long time. So, the next question is, how does this experience affect me as a physician, affect my behavior as a physician? Well, there's good data on this. Following a medical malpractice lawsuit, choose from one of the four. Physician's performance improves. Physician's performance is unchanged. Physician's performance deteriorates. There is an increased risk of second litigation within 12 months of receiving the first claim. As a matter of fact, there's an increased risk of second litigation within 12 months of receiving the first claim. Why is that? Your mind is distracted. There may be something that was going on in your life that took place with the first suit, and it's still going on in your life, and you have a second or a third suit. And we see these clusters in OMIC all the time, that we'll see a person who practiced great for 10 years, and then 2 or 3 claims pop up within 18 months. I've been surprised because with the first 3 answers, it's all over the place. You're quite correct. Sometimes physicians' performance, and many times it does improve. Sometimes you would think that it's improving, but it doesn't really improve, and then there are a few people that just don't seem to do much of anything. So there are changes in behavior, and I experience these as well. In a large series, 70% kept more meticulous records, 60% ordered more diagnostic tests, half of them stopped seeing certain types of patients. Surprisingly, almost 20% reported feeling a loss of nerve when it came to handling cases in the future. Now, it might have been for a short period of time, but there are reports of physicians who could not practice anymore because of what they had gone through, and they just lost confidence in themselves because of that. And that's a shame, because people have gone a long way towards their education, and to lose that, I think, is a big loss. A third, entertain thoughts of early retirement. What about my personal response? Well, I've already talked a little bit about my short-term feelings, but my response to the suit was, I think, one of trying to do a better job and correct myself. And I think I became a little bit overzealous almost in terms of documentation, because I was so fearful about having another problem like this crop up because of my short-sightedness. And I may have been a little bit too harsh on some of the residents or fellows about the documentation that they were putting in the chart. But I slowly, over time, I began to, I think, incorporate it into my teaching and behavior with others, and it's something that I've followed through on now for 30 or 25 years since this event happened. In terms of my intermediate response, I think that it got me very interested in the medical legal process, and it helped me immensely as I was going through my 15 years on the OMIC board, because I would sit on the underwriting committee and I would hear stories about physicians and things that they were happening, making underwriting decisions, as Ann talked about, and I would hearken back to my experience, and I would try to put it into perspective of what had happened. And I think in the long term, what it did is this. It's taking me 26 years to be able to talk about this publicly. And it's really helped me to now come and speak before an audience such as this, to tell them about the experience and to share information about what it's like to go through it, and to point out that you don't have to be alone going through this, that there's help out there and that you should take advantage of it. If I could give you some information on lessons learned about my case, and I think it's true for just about everyone, prepare for involvement over a long period of time. The process and the wheels of the legal system move very slowly. Try to stay focused on the medicine that you're currently practicing and on the medicine that's involved in the case. That is the expertise that you can bring to your particular situation. Read each and every document over and over again so that you are so familiar with the case, and look for the small little things that can help you or may potentially hurt you, and point those out to your attorney. Don't let emotions get the best of the situation. You've got to continue to function as a member of your family and as a member of the healthcare team, and in your private practice or in your academic practice or wherever you are. So you've got to somehow deal with the emotional impact. You need to spend time educating your attorney. If your attorney doesn't understand the medicine, you are sunk. You have got to educate your attorney, and hopefully you'll have a good one that will listen and become educated. Don't try to be your own attorney. Okay? Your expertise is medicine. It's not legal unless you happen to be a lawyer as well. Even then, you know, the worst doctor is being a doctor for yourself, and the same thing about the legal process. Your attorney will help you out. And help your attorney find knowledgeable consultants and experts to help you. Work with your claims representative on the team. You have a tremendous team with your malpractice carrier. They are working on your behalf, not only because they want to, be for the finances of the company and the health and all of that, but because you are their client and they value your business very, very much. They want to help you. Don't be negligent in your response to requests for information. Don't let deadlines pass. It's a real problem if you do. You should plan your day so that you can attend and listen to all depositions. It's not easy to sit there and listen to what the plaintiff's attorney wants to say about you and what the plaintiff themselves may want to say about you and your care. You know that they have their own perspective on it, and sometimes you want to stand up and say, no, that's not right, but you can't do that. But it's important for you to hear it because it will help you understand the situation you find yourself in. Read all of the depositions. Remember, your spouse is your friend. Don't be afraid to confide in him or her, and don't hesitate to seek counseling if you need it. Thank you so much for giving me the opportunity to share this with you. Appreciate it.